Hello everyone. By the time we have discussed about the arbitration, and in this video I will discuss about the mediation regarding the meaning and concept of mediation, types of mediation, process of mediation, advantages of mediation and disadvantages of mediation. Likewise, we cover all these aspects of mediation in this video. So let's begin with the meaning and concept of mediation. Mediation is one of the methods of alternative dispute resolution in which a neutral third party, who is known as mediator, assists parties to resolve the dispute through an acceptable and voluntary agreement. Okay, so here in this sentence you need to focus on certain words. Those are: mediator is a neutral third party. The first thing that you need to focus on. Secondly, you need to focus on assists. Who assists? Mediator. Or whom to assists? The disputants or the parties. Okay. So this neutral third party, who is a mediator, assists the parties to resolve their dispute through acceptable and voluntary agreement. So the another term you need to focus on: acceptable and voluntary. Okay, so it has to be acceptable by both the parties, and both the parties accepting that voluntary without any external force. So I believe now you got the meaning of mediation. So it is a process of dispute resolution where a third party, who is a neutral party known as mediator, helps the parties to resolve the dispute with their own interest. Okay, so this is mediation. The purpose of mediation is to reduce animosity and self-importance between the parties. See, another interesting fact: the purpose of mediation is to reduce, what it does, it reduces the animosity. So if there is any dispute, and because of that dispute or issue, if there is unfriendliness relationship between the parties, say the example of husband and wife, they are so close to each other, and because of some issue, if they develop animosity towards each other, so that is wrong. So mediation first also tries to resolve that animosity, okay, and then the issue. So I repeat this sentence because you need to understand this. Okay, so the purpose of mediation is to reduce animosity and self-importance between the parties and enable them to realize and understand their priorities and interests, and then help them to find a self-determined and mutually acceptable resolution. See again how beautiful this method or process is to resolve the dispute. What all I am trying to say that through such method, it first creates the friendly relationship between the parties and with their interest without imposing or applying any external force, try to resolve the dispute. Okay, which of course supposed to be mutually acceptable, isn't it? Likewise, the mediator induces and facilitates the parties to enter into a positive dialogue. Again, you need to focus on positive dialogue, attempts to break the impasse and enables them to visualize their own solutions in pragmatic manner. So in a practical way, what is the reality, what is the possibility, based on that the problem of the parties being resolved. And who does that? It is only parties themselves do that. Mediator only assists them to do so. Right? So see, here parties themselves decide the resolution. Okay? The idea is to assist people to communicate in a rational and problem-solving manner, clarify issues, and to help negotiations by bringing realism and objectivity to a dispute. It is the intellect of mediator that how he or she effectively monitors such process, okay, supervise such mediation process, okay. So Mediation is, in fact, the technique that empowers and encourages the parties to think for themselves and choose what is right for them so that they can take their own responsibility of arriving at their own decisions. See, I have explained it so profoundly, but the major point that you need to focus on, mediation is a process. So, the first thing that you need to keep in mind, it is a process under which parties themselves try to resolve the dispute. So another point that you need to focus on, parties themselves resolve the problem. Okay, and thirdly, the problem which is resolved by the parties, of course, mutually agreed. So both parties supposed to be happy with that decision because they are making themselves. And lastly, the role of mediator. What he or she does, he or she just assist them in doing so. That's it. So this is all about the concept of mediation. I hope now this point is pretty much clear with you. So now come on the types of mediation. Officially there is as such no types of mediation. Nevertheless, depending upon the nature and some modus operandi, it is categorized into the following paths. Evaluative mediation. Evaluative mediation is focused on providing the parties with an evaluation of their case and directing them toward settlement. So what happens in this type of mediation is, first the problem, the dispute being evaluated, and based on that resolution is being sorted out. Second one is facilitative mediation. What does it mean? That in this type of mediation, the mediator facilitates the conversation and mediator acts as a guardian of the process, not the content of the outcome. So basically mediator supervises and facilitates in such type of mediation. Next one is transformative mediation. Transformative mediation practice is focused on supporting empowerment and recognition shifts by allowing and encouraging deliberation, decision making and perspective taking. So it is, as the name suggests, transformative. So under this type of mediation, the mediator has the more active role in comparison to other, where he or she encourages parties to make the decision. Okay. Next one is mediation with arbitration. As the name suggests, mediation has sometimes been utilized to good effect when coupled with arbitration. What does it mean? That mediation sometimes been utilized to good effect when coupled with arbitration, particularly binding arbitration in a process called mediation arbitration. The process begins as a standard mediation, but if mediation fails, the mediator becomes an arbitrator. So it is mixed with the arbitration. Okay, as it is suggested here, the dispute resolution primarily started with mediation and ended with arbitration. Okay, and the last one that we have, that is online mediation. So what does it mean? As you can understand what could be the meaning of online mediation. Online mediation employs online technology to provide disputants access to mediators and each other despite geographic distance, disability or other barriers to direct meeting. So it is being done with the help of computer and internet, where all the parties located in different geographic location, they meet on the web, on the internet, through their system, through their smartphone, and they discuss the things. Mediator assists them to find the resolution of their disputes. So it is pretty effective in today's technological world, as if party has no time to travel here and there, so that they can get it resolved by sitting at home. So no one needs to go out. The litigation is not feasible online, though in this COVID-19 situation, even litigation started online, but that is not much effective. Temporarily okay, but it cannot be done online effectively. Even arbitration is difficult to do online, but mediation pretty much possible. Now we have another topic, that is process of mediation. It is very important that you need to understand what are the procedure those are being followed while practicing mediation, the concept and then process. In fact, by the time there is as such no legislation that deals with the mediation except section 89 of Civil Procedure Code, which deals with only court referred mediation. What does it mean? That as we have seen while discussing arbitration, we have Arbitration and Conciliation Act, but regarding the mediation, there is as such no legislation. However, section 89 of Civil Procedure Code that deals with only court referred mediation. What does it mean? That once a couple if files divorce petition, especially it happens with the divorce petition, court first asks them to go for the mediation. So it is talking about, section 89 of Civil Procedure Code deals with that sort of mediation, under which court refers a couple, or maybe someone has the property dispute, then even in that case court may ask to go for the mediation first. Okay, so that is court referred mediation. But as such, there is no private arrangement officially. People can do that on their own, but there is no defined rule for that. Hence, pre-litigation mediation is not yet governed by any law in India. Okay, since there is no legislation, no law, no act, no rules, so it is less formal. Okay, lack of legislation, the mediation process is generally an ad hoc process. So there is no as a systematic kind of thing, officially kind of thing in terms of mediation. Rather, it is an ad hoc process which is initiated and conducted by parties themselves. Because of this reason, mediation only begins when both the parties agree to resolve their disputes through mediation. So it is possible only when both the parties agreed to get it resolved through mediation. Okay, so there is no binding as such. However, the process of mediation is conducted under the guidance of a neutral third party who is known as mediator. Okay, now let's check out the process of mediation. So there are 5 steps to complete the mediation process. The first step is appointment of mediation, under which both the parties consensually appoint a neutral third party who is known as mediator, who is usually not essentially a lawyer but of course an expert and experienced person of this field. So mediator has to be a lawyer. It is not a defined kind of qualification. He could be even a person of non-legal background, okay, but expert of such field of mediation. The second step is opening a statement. Primarily, the process starts with the opening statements given by mediator. And what does it carry? This opening statement. In his or her opening statements, mediator first briefs the parties about the purpose, benefits, and of course rules of the mediation. Of course, if you are conducting a process through which you are going to resolve the dispute, you must design some rules. Okay, so mediator in his opening statement, he explains the purpose, benefits, and the rules of the process of mediation. Mediator also explains his or her role and other details of mediation process. Likewise, the objective of the opening statements by the mediator is to make parties feel comfortable and the integrity of their presence. So it's not only explaining the benefits, purpose and all, but also he or she makes the parties feel comfortable that you are a right place. Here you will get the resolution, which of course is of your interest. Okay, so you came here, you are giving your time, it is worth, right? Likewise, he or she tries to develop credibility and trustworthy relationship among the parties, as well as reliable bonding between the mediator and the parties. Okay, so this is the second step, that is opening a statement. Now we have the third step, that is joint session. It is as such not an entirely distinct step. The third step, that is joint session, is not entirely a distinct step. Rather, just after opening statements, joint session commences. It is as such joint session. But before parties start exchanging their information and all, mediator just initiates the process by giving the introduction about him or herself, and then about the purpose and the methods and the benefits and the rules of the mediation process. So everyone sitting in that hall supposed to be knowing the things what is going on there. So that is an introductory remark. Okay, and then joint session begins. So step 2 and step 3, just it's a time interval, but it happens at the same time, one after another. I mean, there is no different dates for that. Okay, so you can say that it is the continuation of opening statements, as it is the part of that. In the joint session, both the parties, in the presence of mediator, keep their points or issues one by one. So both the parties given sufficient time to express themselves. Okay, there is as such no time limit. Parties are given sufficient time to put their points in details. Such discussion and dialogue are extremely significant for settling the issues in an amicable manner. In fact, such dialogue and exchange of information help the mediator to understand the issues with parties, emotions, and perceptions comprehensively. Okay, so when parties supposed to be exchanging their information, their issues, so that help the mediator to understand the issues comprehensively, isn't it? However, mediator needs to ensure that both the parties have been given sufficient time, I am repeating this point, to express their concern and no one feels dejected there. So it's not like mediator just focusing on one party and ignoring the other or giving less time. No, it is parties who decide the content, the length of the time, that how long they need to express themselves. Okay. Secondly, mediator also needs to ensure that the parties are maintaining the decorum of the process so that the discussion doesn't break down. Okay, this is another responsibility in the hands of mediator, that as in the opening statement what he explained, along with the purpose and benefit, that is rules. So that is the purpose of this opening statement, so that the party can maintain the decorum of the process. Besides, mediator must not permit any rigid adversarial elements to enter in any physical or even verbal argument, so as to prevent the derailment of the mediation process. What does it mean? That maybe they are in dispute, maybe they have the concern and the disputes, so that, and this is why they are there. So in that condition, there is possibility both the parties may start abusing each other, maybe sometimes physical with each other. So mediator needs to control all those things. So this is why mediator needs to ensure that the decorum of the process being maintained. Okay, only then the resolution possible, otherwise it is impossible. Okay, mediator should utilize this time as an opportunity. See the role of mediator, that is the point you need to focus on. So I repeat, mediator should utilize this time as an opportunity to understand the parties' issues and of course the priorities. Okay, so once the parties start sharing the information and issues, then mediator start getting the real fact of the case. Here he or she can understand the close gap between the facts and the parties. Okay, differing perceptions, as it will ultimately help him or her to understand their positive aspects of the relationship. Okay, so he needs to also understand what were the relationship prior to that dispute. Okay, so it requires a lot of attention there. So mediator needs to be focused in their discussion, keep listening so patiently. Okay, moreover, this is another important point that you need to focus on, that is, at this moment mediator shouldn't arrive on any decision or make any conclusion or even suggest anything to either of the parties. Instead, focus only on understanding the genesis of the dispute. Okay, so just keep focusing on the point that mediator is a passive agent. See, he is just listening and supervising the process, isn't it? Otherwise, he is not speaking anything. Okay. Now, once joint session is done, then the process goes into the fourth step, which technically known as caucus, which means individual session. After the joint session, mediator, for better understanding and also giving more space to each party, calls each party for separate meeting, which takes place on different dates. Okay, so mediator meets with each party individually, that is one to one. Okay, and not essentially on the same date, maybe on different dates. Okay, the purpose of such one-to-one meeting with each party is to encourage parties to share all other information that normally he or she cannot share in the presence of other party. Possibly, husband in presence of his wife not may able to express all those points what he wants to express, and vice versa. है ना? So when they are alone, then they can share more information, right? And that will help mediator to resolve the dispute. Okay, so meeting privately gives a chance to parties to open up and express every concern. On the other hand, such a step gives opportunity to mediator to further explore the issues in detail. है ना? At this stage, mediator encourages party to speak up everything. So for that, he or she may ask questions or even counsel to his or her parties. So in this session, mediator may ask certain questions, and that intention is only to understand their concern. So he or she needs to show his patience to listen the issues of parties in detail so that he can or she can understand, right? But keep in mind the information shared by each of the parties. Mediator is not expected to share or disclose each other's information with the opposite party in any given condition. So whatever the information shared by one party, that has to be confidential, because parties believe or trusted on the mediator and hence shared the things. So he or she doesn't supposed to disclosing one's matter with other one. Okay, this is unethical. However, he or she can use that information ingeniously and resourcefully to settle down the dispute in an effective and amicable manner. So if he is or she is smart enough, I am talking about the mediator, then he or she can use those informations that is shared by the parties privately to resolve the dispute. Okay, so not essentially, but depending upon the case, the process of caucus, you understood the term caucus means one-to-one meeting, okay, may be repeated. So what does it mean that caucus means the meeting with one party? It not always mean that in one session the problem will be resolved. Depending upon the case and situation, mediator may ask for 2 or 3 sessions with each parties or with one party. That depends. Or in other words, mediator may conduct 2 or even 3 sessions with each party separately. Okay, so that's the fact. Once caucus is done, then we have the 5th stage, and that is the last stage, agreement and settlement. Settling the case through a mutually agreed agreement is the final stage of successful mediation. Focus on successful mediation. If it is not successful, then there is no value of such agreement. So in this stage, mediator, as agreed by the parties, again focus on as agreed by the parties, makes the mutually acceptable agreement. Okay, the settlement agreement is pretty comprehensive, that enlists all the points that serve the effective solutions along with the respective terms and conditions. So whatever the terms and conditions and the things being decided between both the parties, mediator's duty is to pen down on the paper, enlist on the paper. Okay, so it includes every aspect of the dispute, leaving behind no scope for further confusion, neither in respect of the dispute nor in respect of the enforcement of the settlement. Okay, so everything is being noted there in that agreement. And finally, the settlement agreement will valid only when both the parties duly sign over it. So once the agreement is formed, drafted, then both the parties willingly sign over that, and once they signed, it is binding upon both the parties, right? If they are not signing on that, then they are free. In that condition, they can find the other ways of their dispute resolution. So these are the 5 steps of mediation. I hope you must understood. Okay, so again take a recap of these 5 steps. I believe that will be helpful for you. The first step that I discussed, that is appointment of mediator. So process of mediation starts with appointment of a mediator. Then the opening statement and joint session collectively, although I have explained through 2 different steps. And then the fourth step, that is caucus, that is one-to-one meeting or individual session. And then the last one and the 5th stage, that is agreement and settlement, where agreement is being drafted based on their agreed understanding. Now we have advantages of mediation. Like arbitration, mediation has also number of advantages. The first one is it is simple and flexible. The process of mediation is pretty simple, less formal and flexible, as parties can customize as per their convenience. Okay, so parties has full freedom to customize the process of mediation as per their convenience. Okay, so there is as such no formality. The second one is economic and less expensive. Mediation is very less expensive method of dispute resolution that saves lot of money in number of ways. Okay, so here everything that is in your control, and the money is of course so economic that can fit into your budget easily. Effective and time saving. Mediation process is effective in the sense that it gives opportunity to both the parties to resolve their dispute by themselves. Since both the parties deciding the things as per their interests, so it is effective and makes it possible merely in a couple of weeks or in a month. So such resolution can be done merely in couple of weeks or in a month, maybe sometimes 2 months, but rarely. Next one is Gibbs creative solution. Mediation facilitates parties to devise a creative way or even customize the methods and decision on their own ways. As in this method, parties retain full control over it. Big advantage it has. Okay. The next one is maintaining the confidentiality. Like arbitration, mediation is an entirely closed door and private method of dispute resolution, which guaranteed maintains the confidentiality of process, disputes, issues, and final outcomes. So there is no scope of disclosure of such kind of thing. So even the issue, dispute, and process and outcome, everything is so confidential under the heading of mediation. Okay. The next one is preservation of relationship. This one is one of the biggest advantages, that mediation preserves the parties' friendly relationship by giving opportunities to both the parties to resolve the dispute by themselves. In fact, mediation encourages on transparent communication, participate and collaborate with each other, and understand each other's issues and interests in a composed and friendly environment. It focuses on long-term bonding and fosters healthy and everlasting mutual understanding between the parties. So this is the most beautiful aspect of this mediation process. So that you get the resolution, but not at the cost of relationship, isn't it? Relationship also being maintained here. The next one and the last one is win-win situation. Since it promotes mutually acceptable resolution, hence through this process both the parties win the case and no one in fact loses the case. Okay, so see how many advantages mediation has. Okay, now it has so many advantages, it doesn't mean that it hasn't any disadvantages. There are a few disadvantages as well. That is no legislation. What does it mean? That since there is no provision and rules that define the proper means of mediation, therefore it is less formal and less binding upon the parties. Okay, lack of trust, and it is related to the first one, that is no legislation. Since the execution of decision is not binding in very effective way, so it is less trustworthy. So no legislation that leads to less trust. People think that how it will be executed, the decision is not binding, but it is not like that. If the parties signed over the agreement, it is binding. Okay, the third and the last disadvantage is least known. In spite of having so many advantages, the mediation process is not known to many people of the country. Moreover, unquestionably, mediation is one of the best ways of dispute resolution, which has actually a number of advantages. So very soon it is going to be one of the most preferred dispute resolution methods in India. So you can think on this aspect as well. So this is all about the mediation. So I am going to wind up my video here only. However, before saying you bye-bye, I want to have a quick revision of the points that we have discussed in this video. Okay, so first I started with the meaning and concept of mediation. Then we have discussed the types of mediation, under which we have discussed evaluative mediation, facilitative mediation, transformative mediation, mediation with the arbitration, and online mediation. And then we have discussed about the process of mediation, under which we have discussed the 5 processes of mediation, starting with the appointment of mediator, then the opening statement, then joint session, and then caucus, that is individual session and individual meeting, and fifth and the final one is agreement and settlement. Okay, and then we have discussed about the advantages of mediation and disadvantages of mediation. So this is all. I hope you must understood now what mediation actually is. So see you in next video with a new topic, that is conciliation. Keep watching.